So let's just jump in. So we're focusing this afternoon on the new Supreme Court foreclosure rules, which are 99.1, 113, and 114. And just give a shout out. I just want a little verification that you saw my slide change just now. I assume you all did, but if anybody can just give me a yes, since this is the first time I've done this. We're now off the title page. Good. It looks like we're good. So I participated on a Supreme Court Rules Committee that was convened specifically to look at the mortgage foreclosure problem a couple years ago now, back in April 2011. So each of the two Supreme Court justices invited two participants to join the panel. So we had judges, retired judges, some attorneys from each side, foreclosure plaintiff, foreclosure defense, some representatives from some smaller community regional banks, the Attorney General's office, and a law professor from University of Illinois. And then Manny Flores, the then director, Division of Banking, who's now the acting secretary at IDFPR, came on and was a great addition, since that's the office that regulates mortgage lending and mortgage servicing for the state of Illinois. And the purpose was, as stated here, quote, to study and formulate proposals to help those facing the loss of their homes and improve the judicial process in mortgage foreclosures throughout Illinois. So kind of a two-sided purpose, to help homeowners who might be able to stay in their homes. Obviously, that's near and dear to my heart as an attorney at LAF, working for homeowners, and also sort of to just generally improve the efficiency or smoothness or clarity, of what's going on in courtrooms, given how incredibly packed and full they are with foreclosure cases, have been in recent years. It's kind of a larger, judicial, smoothness, economy sort of purpose. So just very quickly, we met for about a year, came up with some proposals, some public hearings last summer, met again, amended rules, sent proposed rules in the fall, and over the winter, the Supreme Court adopted them, and they started going into effect March 1st, and then some went into effect May 1st, and we'll look at those in more detail. So Rule 99.1 is the mediation rule. It went into effect March 1st, earlier than the others. And as I describe it here, it sort of gives the Illinois Supreme Court a kind of checklist of items to look for in approving mediation programs. So, I mean, in a way, this rule is the one that does or mandates the least. I mean, it doesn't really mandate anything. It simply gives a little bit of guidance to the Supreme Court, which they were looking for in terms of approving or not approving mediation programs that are presented to them. Because the way it works in Illinois, as I'm sure many of you know, is that a county, if they're interested in implementing a mediation program, has to apply to the Illinois Supreme Court to do so and seek and get permission. And in the past, before our committee met, there were already in place, or I guess I should say at least by now, by the time that the committee ended, there has been put in place mediation in at least these 6 counties. And somebody tell me if I've missed any. Maybe there's some newer ones too that have cropped up in recent months that I missed. Let me know. But basically, like in Cook County, we had one for several years. The Supreme Court was approving programs, but really wanted more guidance. What's important, what should we be looking for, what should we have in a good mediation program that works. So we did some study on the committee of some of the mediation programs around the country, looked at Cook County and Will County, since we had practitioners from both of those. And we were meeting in Cook County, and those are both right here. A couple of the older counties to have them, sort of looked what's working, what's not working, and just sort of put together a checklist of things that, in a sense, the ideal program should have or should at least address. So before getting to that list, yeah, I just have a couple of maps up here. So again, these are the counties that have mediation programs. Again, if I missed any, somebody type that in. And map coming up, which pertains to the recent round of Attorney General grants that have gone out to various entities that are looking at helping counties, who decide they want to implement new mediation programs. So this just gives the details of the AG grant that went out the past few months and what it's intended to do, and basically it's to set up new mediation programs for counties that are interested. And so as this money is going out there, obviously more counties have more resources to be able to think about this and do this, and that sort of goes together with the Supreme Court wanting to know, okay, when people come and apply to us, what should we be looking for? So I'll just skip over this quickly, although I will kind of come back to and mention that last one, that last bullet point there at the bottom about evaluating and reporting outcomes and efficiency of mediation programs. Just keep that in mind. And then here's the second map. You can sort of look on your own at the various districts where the new AG money is sort of eligible to be used to be looking at and considering mediation programs. But back to the rule, the sort of checklist that we created was this. So if you're submitting a program plan for approval to the Supreme Court, the plan has to address HUD certified counseling. Obviously, everybody pretty much agrees that counseling, and particularly good nonprofit, no cost, to the borrower, HUD certified housing counseling is critical, if at all possible. Pro bono legal representation is critical, at the very least to help with some of the loan bond negotiations and to at least give some basic, review of legal claims, language access for limited English proficiency speakers, obviously costs that are going to be charged, and financial sustainability are critical to address, talk about in counties' plan to have mediation, and training. So these were the things that have to be addressed, and as it says above, list is suggestive, not mandatory. And the way I think of it is that this list kind of sets a sort of rebuttable presumption. You've got to have these elements, and if you don't, if you can't, if you're a small county, you can't get the finances for some reason, something's unworkable, where you are, you sort of have to address it and convince the Supreme Court why, you should sort of get an exemption or a variance, and be able to go forward with a program that doesn't, for instance, have, pro bono legal representation for everybody, or language access, depending on where you are and who the participants are, or maybe a different or limited kind of language access. If there was none, that probably wouldn't get you very far. And I think that, since we had the AG representative on the committee, obviously with the AG money going out that I mentioned earlier, it was hoped that would make it more feasible for more counties to be looking at doing mediation. And of course, with changes in the statute, in the statutory law in Illinois, and additional fees being imposed on sort of large volume foreclosure filers this year, there should be hopefully some more money available that could also go to funding mediation and housing counseling, for instance. So again, it's not customized or mandatory or one size fits all, but if you're somebody who's involved in looking at trying to get mediation or shape mediation, in your county, in your district, wherever you are, these are the big ticket items to look at. We didn't, we purposely didn't address the issue of whether a program would be voluntary or mandatory. In other words, whether every homeowner, every foreclosure defendant had to go into the program or not. Because we, I think, realized that there's strong arguments on both sides, and it often depends on, what county you're in, how many people, how many cases. We don't have mandatory in Cook County because there's so many cases, and it just was never going to happen. So that's not addressed. Or whether the lender representative must be physically present. I mean, that's something that has been mentioned to me as being a very effective feature in the Will County program. At a certain point in the process, a lender rep has to be there, not just on the phone. So that obviously can bring a lot of leverage to bear. Again, something I think worth looking at, but we weren't about to say that that was something that needed to be mandatory for all programs. There's also nothing in there, although we discussed it a lot, about data and outcome tracking systems. But as I mentioned earlier, that is specifically a feature in the AG grant related to mediation. So people applying for that money, have to talk about tracking and evaluating and reporting. And obviously that's a good thing. Obviously it's important to see if the program's working and to see, to the extent possible, how much impact it's having, to tweak the program, make changes, as needed. And for instance, in Cook County, there's definitely been some major changes along the way when problems were perceived, such as the addition of case managers a year and a half ago. So that's pretty much it, an overview of 99.1, the mediation rule. And I just put this slide in to kind of illustrate that it doesn't really relate so much to Rule 113, which has to do with regulating the content of things filed and types of notices that have to be filed. Largely after mediation would occur, although some also at the very beginning of the case before mediation would really be in process. Rule 114, which we'll talk about, does relate more to mediation, or ideally it should, because that's the loss mitigation affidavit, which hopefully can and should be integrated into the county's mediation program. We'll get to that. Any questions so far? I could pause here naturally just for a moment if there's a question or two on that first rule. Hearing none, of course I can't hear anything, but also seeing none, I will continue. And we'll dive into the meat. So Rule 113 is the practice and procedure in mortgage foreclosure rule. And on the committee, we were broken up into, or two different subcommittees were formed. So one was practices and procedures, and one was loss mitigation and mediation. So the practice and procedure subcommittee, headed by now Justice DeLort, really focused on the stuff that ended up in Rule 113. And on the other subcommittee, we were focusing on what ended up in Rule 99.1 and Rule 114. So just important to note, or as a reminder if you already know this, the effective date for Rules 113 and Rule 114 is May 1st, but they work a little bit differently. So with Rule 113, the May 1st effective date means that Rule 113 only applies to cases that are filed on or after May 1st. So that's important to remember. We're probably, what is it now, coming up on 3 months, 2 months. Yeah, it's only been a couple of months since the effective date, so probably most cases that you see and deal with still were filed prior to May 1. Rule 113 would not apply, but you may start to see some, and more obviously, where 113 will apply. And I think that there are a few, modestly helpful changes to the mortgage foreclosure process that were implemented by Rule 113. And I think the big ticket items are the following that are on this slide. There's some discussion of what has to be attached to the complaint and some helpful changes that I'll talk about. There's some specification of what form the prove-up affidavit has to be in, the affidavit that the mortgage company is using to get its judgment, to say how much that judgment is. There's some new and specified required notices. There's a couple of extra protections for cases, granted not too many anymore, but there still are some, where there are surplus funds for the homeowner after the home has been sold. And all those cases where the mortgagor is deceased and now they're pursuing the mortgage debt, pursuing the foreclosure, and it's the heirs who are dealing with this, there's one provision in there that sort of reinforces some prior case law. So this is my tricky slide. Let's see. Let's play lawyer. If you are a lawyer, then be that lawyer. It's been a while, so what do we have here? Okay, so I'm just going to go ahead and put all these on here because it doesn't really work unless you are in the room. So Rule 113B says that the plaintiff must attach to the complaint, quote, a copy of the note as it currently exists, including all endorsements and allonges. All shall be attached to the mortgage foreclosure complaint at the time of filing. How is that different? So of course, there's the answer. It adds to the current requirement, which currently states only that a copy of the note must be attached. So let me slow down and sort of amplify this point a bit. So right now, in the Illinois mortgage foreclosure law, the statute that governs all mortgage foreclosures that are filed and says how they have to be filed in the state of Illinois, it says when you file the complaint, you follow the statutory form and you lay out all the facts, and then you have to attach a copy of the note and the mortgage. So for those of you who are not lawyers, you may know this anyways, but just to reiterate, the note is the loan. It says how much you're borrowing, under what terms, and when it's due. And then the mortgage is the separate document that's the security instrument that secures the note. It says if you don't pay, you can give notice, you can foreclose. So the note and the mortgage. And so the current law just says you got to attach a copy of the note and a copy of the mortgage. So what's often confusing and arguably leads to legal defects in the case and is just a mess, frankly, is the fact that, maybe not so much these days, but certainly in prior years, lenders would file the foreclosure case and attach the note and the mortgage. And it was just the note and the mortgage as they existed, on the day when the note and mortgage were executed by the borrower, the closing, 3, 4, 5, 6, 7 years ago. And so you have a plaintiff who's suing, say Citibank or City Financial is suing, and the note is simply the note that was originally made out to, Fremont Mortgage, long since defunct. And so it creates confusion. There's arguably lack of standing, or it's not apparent. So to clean up the mess, this change says that a copy of the note as it currently exists on the day that you file the case, so including all endorsements and allonges, and those are just fancy legal words, if you're not lawyers, for ways that you can show that the note has been properly transferred to City Financial in my example. That has to be the copy of the note that's filed, that's attached to the complaint, so that anybody looking at it can see, really anybody can see that, okay, this isn't just the note that was made out to Fremont 5 years ago, but there's an endorsement here. It's now paid the order, signed by Fremont, over to City Financial. So there's at least an initial indication that this plaintiff, on the day it filed, has the right to file the case. And so it also sort of makes the lenders get their ducks in a row. And they can't be as sloppy, and if they can't actually find a properly endorsed note or a copy thereof, they're in trouble, and there could be discussions as to what other kinds of things they may try to do to prove up their case, but it's going to make it harder for them to kind of skimp and engage in a lot of the shoddy practices, filing practices that they've engaged in the past. So it's a good thing. So I've talked about the note. As I go through here, you can see I say in that third bullet point in italics, well, what about the mortgage? And then I answer that question in the next bullet point by saying, no, Rule 113 does not require a copy of the mortgage as it currently exists because, and this is just a basic legal principle in Illinois as in most states, the mortgage follows the note. So the reality is if the note's properly endorsed, then the mortgage goes along with it. You get to foreclose. So there's another kind of tricky question I posed. So will the plaintiff now always be the same as the name on the note as endorsed? So in my example, I said, Fremont's endorsed it to City Financial, and City Financial's suing. Will there always be that one-to-one unity where I can see the name of the plaintiff, on the note? And the answer is no, last bullet point, because the plaintiff might still be different from the name on the note because it could be an agent, like the servicer, that's named as the plaintiff. Because in Illinois, the owner of the note, or if there's a different company that's servicing the servicer, either one of those can be valid plaintiffs. So it's not going to completely resolve the confusion that may exist because you see a name on the as the plaintiff and you don't find that name on the note. But it should be true in many more cases that those two names are the same. So there's really only so far you can go, but it's helpful in that way. Ask any questions as we go along if you have any. But otherwise, I will continue. I just threw this in there kind of as a further point on what I was just discussing. Will you always see the name of the plaintiff on the note? An endorsement can be paid to the order of blank, which is called bearer paper, and that is legitimate. If somebody writes paid to the order of Dan Lenz, well, paid to the order of blank and gives it to me and I possess it, I can enforce it even though my name's not on there. So that's another time when you're not going to necessarily see the name of the plaintiff on the note. So, in my mind, really, the two biggest ticket items in Rule 113 are that I just described and this, the prove-up affidavit. So, Rule 113C says, well, so let me take a step back. Robo-signing, obviously, is a term many people have heard and read about, and this was the big scandal nationally, the high volume filing and processing of foreclosure cases, the sort of fraudulent stamping of and signing of names, attesting to things when nobody was really looking at the underlying documents or didn't really have the ability to be a proper witness. Led to the big national mortgage case and national mortgage settlement. So obviously it was much on the mind of the committee, and one of the purposes really was to say how can we address, if at all, this problem of robo-signing. So I think one of the desires was to clean up or tighten the requirements for prove-up affidavits. The basic affidavit that has to be filed and signed by a competent witness, somebody at the servicer, probably the loan servicer, saying that I work for City Financial and this is my job, and I looked at our records that are organized this way, and I looked at the file, and this is what I see, and this is what I believe to be the case, and here are the numbers. So it tightens up and really makes the affidavit more meaningful. I mean, there used to be just some really thin, shoddy, crummy affidavits, as well as, the robo-signing problem. So that's a little different. It was fraudulent signing, and there was also just really shoddy affidavits. So the form affidavit, that I don't reproduce here, but it's in Rule 113, is somewhat stiffer than it used to be. And another thing it does is, in addition to sort of talking about and identifying the records relied upon, the second bullet point here, the payment history has to be attached if there is a defendant who has filed an appearance or responsive pleading. So if it's a case where a defendant has gotten involved and filed an appearance or an answer or a motion to dismiss, then when you get to the point of trying to get your judgment lender, you have to automatically include a payment history when you move for judgment. So that is some, bit of information and sometimes useful information that will automatically be filed and provided to the defendant. And many times it's difficult to get that, as a pro se defendant certainly, and sometimes even, as a lawyer representing a defendant. Identify the computer software used. Provide additional evidence as necessary to show right to sue. Now hold that thought for a moment. This, I think, is where you get back to the notion that in Illinois, you can be a plaintiff and you can sue if you're the servicer. But if you are, then in my mind, right here, you have to show some evidence that you're the servicer. You have to show some evidence that you have the right to foreclose on this loan, even though you're not the owner of it. Even though that note endorsed it to X, and you're servicer of X, and you want to foreclose and get your judgment, you need to show that prove that you're the servicer of X on this loan, and that you have the right to foreclose. So that's a little something extra. And then follow the form affidavit, the last requirement. And in terms of proving up the amount due and owing that has to go in the judgment, and plaintiffs sometimes forget this. They can't just get a judgment. They have to specify the exact amount that's due and owing at the time they get the judgment. This is definitely better than many plaintiffs were doing, or what it requires in terms of specificity is much better than what was often being given. I mean, I think, again, like with a lot of this stuff, it has gotten somewhat better. There's been some self-policing or some attempt to do better by some of the plaintiffs in some of the cases recently. But anyhow, this kind of makes a good standard. So you have to put the principal that's owed, the interest, the insurance, if there's any insurance, pro rata MIP or PMI insurance payments on the loan, escrow advance. So if the lender has paid taxes or insurance, then they have to put that under escrow. Any late charges, NSF charges, bounce checks. You're charging the borrower for a bounce check. Property maintenance or inspection. BPO, that's a broker's price opinion, to value the property as the foreclosure case goes through. And then you finally get a gross amount that's due. And then I think this is helpful because it was sometimes neglected. Less any balance in reserve, that dreaded suspense account. So if you've got half a month's payment sitting there, that has to be credited, and you get your net amount due. And all this is what's due on the loan account. Plaintiff still has to submit a separate itemization for attorney's fees and court costs. So again, I think it at least raises the bar somewhat and gives clarity as to what's required. There's a couple other things in Rule 113. If a notice of default is entered, then a judgment, if a default judgment is entered against a homeowner who hasn't participated or answered, then the lender has to mail within 2 business days a copy of the notice, even if nobody's ever participated, copy the notice to the property address or to the address that is on a document if a document has been filed. And in Cook County, at least, I've seen a very specific order telling the lenders exactly how they have to prepare this notice and how to mark the envelope that it's going in, and then it has to actually be given to the clerk, who then mails it out. So just one place where there's an extra attempt to make sure people know what's going on if they haven't been involved otherwise. And Rule 113F is a notice of the sale if the case is at the end of the process and going toward judicial sale. And it has to be mailed 10 business days prior to the sale to all defendants. And I think this is important. It's small but important. Currently, the state statute only requires notice of the sale be mailed to non-defaulting parties. So if you never participated, you do not have right now under state law a right to the notice of sale, or you didn't prior to Rule 113F. So as for cases going forward, everybody, all defendants, regardless of if they've answered, participated, whatever, have to get notice of the sale. And there's a required notice for and form for if there's surplus funds, just to try to keep sort of surplus proceed scammers from ripping people off in terms of people collecting surplus funds. There was a good Illinois appellate court case decided recently, Crown v. Young, where this company, Unclaimed Funds, had client assign the right to the surplus, which was $14,000, in exchange for a mere half the proceeds plus $50. So basically, Unclaimed Funds was taking, let's see, how did it work? $7,000 plus or minus $50. Absolutely unconscionable, voided by the court. So these kind of things still happen, and the notice and form here intended to help clamp down on that some more. And finally, in terms of Rule 113, there was case law which said that if there's a deceased mortgagor, then the court can't go forward with the case, unless they appoint a special representative to sort of stand in the shoes of the deceased mortgagor. But I guess it was felt that wasn't uniformly followed or applied by all the courts everywhere in Illinois, so this rule makes it crystal clear that you can't just go forward if there's a deceased mortgagor unless you appoint a special representative. If a probated estate's been opened and there's like an administrator of the estate and it's all official that way, then that person should be, the defendant. But otherwise, the court can appoint this thing called a special representative. Questions before we hit Rule 114? My favorite part, of course, since this is what I worked on the most. Okay, either there's no questions or just none are coming to me. So I will forge ahead. So Rule 114 is also effective on May 1st in a different way. It applies to all cases in which no judgment of foreclosure has been entered as of May 1st. So in other words, even if your case was filed 2 years ago, the bottom line is there's no judgment and the lender wants to go, move for judgment, summary or default, next week, then this rule applies. They have to first file a loss mitigation affidavit. And what the law or the rule says is that you have to comply, first of all, with any applicable loss mitigation. So toward the bottom here, plaintiff, prior to moving for judgment of foreclosure, must comply with the requirements of any loss mitigation program which applies. So it could be HAMP at the federal level. If it's an FHA loan, FHA insured loan, special requirements. It could be VA, and of course HAMP has a whole bunch, HAMP 1, HAMP Tier 2, second lien programs to the extent those apply. And anything under the National Mortgage Settlement. And really, there's stuff coming online that the Consumer Finance Protection Bureau has put into place. It'll come online in 2014. That also will apply. Much of that list I just gave in the flavor of needing to see if there's a way to do loss admit, way to do loan mod before filing the case. So although this is later in the case, this is just before you get judgment, it may well apply to things that should have been done and weren't done before the case was filed. So it is definitely, I think, a way to stop a judgment, even if something was non-compliance, before the case was filed, not necessarily just after the case was filed. So you have to comply with loss mitigation, any loss mitigation that applies. And again, if there's some new program that comes online, some state program or local program, that would apply too. And that's Section A. Section B says you got to file an affidavit to show that you complied. In order to document the compliance required by paragraph A above, plaintiff prior to or at the time of moving for a judgment must file an affidavit specifying. And just a word on this, we sort of started on a committee looking at different options and including some extremely long, complicated checklists that everybody groaned about, and I think even I sort of groaned about, and I think everybody agreed that really at the end of the day it was better to just have a kind of more simple format, which we have here. So basically the lender simply has to state any type of loss mitigation which applies, HAMP, VA, FHA, in-house, Attorney General settlement, what steps were taken to offer that type of loss mit to the mortgager, and the status of any such loss mit efforts. Did we reach something? Didn't we? Are we still waiting for something? What's going on? Presumably, in most cases when these are filed, number 3 is going to be, we offered it and we didn't hear from them, or we offered it and they failed to cooperate with the forms we needed, or they weren't eligible, or we offered it and they defaulted. Because here's the point where they are actually going forward and seeking their judgment. So certainly the intent of the committee was not just to say, oh yeah, they've applied and we're considering them, but we want to get our judgment now. And granted, it would have been hard, if not impossible, to get a explicit language here that says, you cannot get your judgment until you've exhausted all loss mitigation efforts and said that you have in your affidavit. We just weren't going to get that. The committee and probably the Supreme Court wasn't going to impose that on judges everywhere. So it's still written in sort of a may form rather than a shall form. But it certainly gives judges the ability to say, hey, either you didn't produce the loss affidavit, or I see you've produced it, but it looks insufficient to me, or it looks like what you're saying is that you're still trying to work things out with the borrower, so no, you can't have your judgment yet. It certainly gives judges the ability to hold off on entering judgment and to say either withdraw your motion or postpone your motion, and hopefully that's what they'll do. That certainly is the intent. I know it was the intent of most of us or all of us on the committee. So that's the actual format it takes in terms of the 3 kind of factual elements that have to be pled. And this gets to the enforcement that I was already starting to talk about. I mean, the court may either sua sponte, so on its own, or upon a motion of the mortgagor or the defendant, stay the proceedings or deny entry of judgment if plaintiff fails to comply with the requirements of this rule. So again, that should mean, didn't file the affidavit, file the shoddy affidavit, or hopefully, judges will look, and if the affidavit shows that, they're still in the middle of trying to get a loss mitigation that's been asked for, they shouldn't go forward. And certainly, again, if there's some loss mitigation requirement that they've already failed to comply with, like before the case was filed, they were supposed to do X, and they haven't. They never did X before they filed. Certainly, if there's not some kind of loan mod or other loss mitigation in place, I would certainly argue to the court that they should not get judgment. So it obviously is a big area that remains to be seen what will happen, a big area where advocates need to push to make the loss amendment affidavit as effective as possible so that its teeth isn't just, sort of token provision, but it's there. And I guess just sort of an early initial reports from Cook County at least, certainly the judges are quickly becoming aware of the existence of Rule 14. I've seen plenty of plaintiffs' attorneys step up on motions for judgment and withdraw the motions because they didn't have the affidavit, because of course this just went into effect fairly recently. I've seen, judges ask for the affidavit, and if they didn't have it, say to the plaintiff's counsel, well, I can either strike your motion or you can withdraw it, and force them to withdraw it. I have unfortunately heard of and seen one or two examples where it felt to me like the judge was being a little too accommodating and was sort of letting the briefing on a motion for summary judgment go forward. In fact, we have one, even though there's no loss amendment affidavit. And at least when we raised the objection, the judge was like, well, maybe they'll have the affidavit. You'll have your decision or an affidavit, by the time it's time for the hearing. I mean, I don't think that's proper, because the rule does say when you move for summary judgment, you're supposed to have filed the affidavit. In any event, when we responded to the motion for summary judgment, we certainly said, they have not filed the affidavit yet, and in fact, worse than that, they haven't responded to our request for a loan mod, and that's what the affidavit's all about. So it's both substantively not responding to our request for a loan mod under HAMP, which is a violation, and not, filling out a loss amendment affidavit, which would show that they're not complying, and that itself is a procedural deficit. So, sort of both of those arguments we're putting out there, and that's still pending. I've seen, I guess so far, 2 loss amendment affidavits, and they were actually pretty good. I mean, the 2 different firms had 2 different forms. They were both types of checklists, basically, and said, that they HAMP applied, for instance, and we tried to reach out to the borrower, and they didn't respond. And I guess in a different one, they processed the person for HAMP, and they failed to qualify. And the second one actually was our client, and so I know it was actually true. They really did have insufficient income, so it wasn't bogus. So those 2 that I've seen, it looked like they were making, legitimate efforts to try to comply. But I would be really, really interested if anybody out there, housing counselors, but probably more likely attorneys, if you see anybody with a Rule 114 affidavit, I'd love to collect examples of what these different affidavits look like, because obviously the different firms and lenders are kind of customizing it, and they're allowed to do that as long as it provides the basic information that's required. If anybody has seen one of these Rule 114 affidavits anywhere, can you type it in, send in a little chat message, and hopefully I'll get it directly or indirectly. But also, again, if you have one or get one in the future, my email's at the end of this slide. If you don't already have it, please send me a copy. That would be great. A last point, I guess, on Rule 114. I mentioned this sort of earlier on. There is an interface with mediation, and thus with the Rule 99.1. What we put in the comments to Rule 114 is that where counties have mediation programs in place, it is advisable that the county adopt procedures to incorporate the loss mitigation affidavit into the mediation process. Right? It certainly makes sense for whoever's involved in the mediation process, the mediator, the counselor, the advocate, to all be on the same page and know what loss mid applies and what's the ongoing status of it. So, instead of the lender just putting something together right at the last point, claiming that mediation's failed and claiming they want their judgment, it would certainly be better if the judge imposes a rule or the court imposes a rule, some kind of procedure requiring the lender to fill that affidavit out earlier on, or maybe fill it out once at the beginning of the mediation process and update it once at the end, or something like that. So that's kind of out there to be used as people want to. So this was a last slide, I think, that I had used particularly when we were training and talking to people face to face. But I think it still has ability. The idea is just, what are maybe some of the little things to look for that have to do with these rules. If you're maybe a housing counselor looking at a case or working with somebody and thinking about maybe making a referral, not just to us, but to any attorney, any legal aid agency. So basically, the first is just if you see a foreclosure that's filed against somebody who's deceased and you don't see that special representative appointed, and that actually has to be in the caption, it has to be, the case has to be amended, the complaint has to be amended, the case has to be reserved. So, lenders used to always just go forward against the dead person and heirs and just go their way, and they can't do that anymore, and so they need to jump through those hoops, and that can make a huge difference and probably adds at least 6 months, if not a year, to the overall timetable. If you see a motion for judgment of foreclosure and it either doesn't seem to comply with that form affidavit that I mentioned earlier that has all those details that has to be given by the affiant and all those line items in the accounting, or if there's no loss amendment affidavit, or if the loss amendment affidavit looks really token. As I mentioned earlier, these additional notices. So if a case is going towards sale and the borrower did not receive notice, again, now every defendant in every case has to get notice of the sale. So whether or not they were involved in the case earlier or not, they should have gotten a notice. So we'll certainly take cases here, even on the eve of sale, if it seems like there's something there that we can do. And again, actually that Illinois appellate court case I mentioned with the surplus scam, we got involved in at the appellate level. So we sometimes get involved when there's some surplus scam or weird wrinkle or different people fighting over the surplus. So attorneys can certainly be helpful with that circumstance. So I think that's all. There's literally the last slide with my name and number and email if you have any follow-up questions. Or again, if you encounter any Rule 114 affidavits, I'd love to see them. And that's pretty much it.
Everyone, this is David and Bob at Housing Action. Dan seems to have got disconnected from the call, even though we can see him. Are there any questions that haven't been answered, David?
Not yet.
Not yet. So we'll wait a minute or so to see if Dan calls back in. Tomorrow, everyone will be getting an email link with or getting an email with a link to the slide presentation and then also a brief evaluation survey. And then if you do have questions that you weren't able to ask Dan today, send those along to us and we'll forward them on to Dan. I guess that's it. I don't know what happened to Dan. So we just end the webinar, David?
Yeah, so thank you very much, everyone, for participating. And again, as Bob said, you will be receiving an email tomorrow with the PowerPoint presentation and also a link to the survey. And we ask that you please respond to the survey because it helps us to put together more webinars like this to provide more information for you. So thank you very much and have a nice afternoon.